Okay, so I apologize for that. We're all set though. So I want to say good evening to everyone who's joining us. I'm really happy to see you all. I think these are really important classes and this is a really important topic. And for any of you who don't know me by now, my name is Kimberly Connell and I'm the Caregiver Services and Supports Coordinator with Onondaga County Office for Aging. And whenever I'm talking with caregivers that I support about the kind of education topics they most like for us to present through these eye care classes, one of the top 5 is around financial concerns with caregiving. And so many of us don't think about it or prepare for it until there's a crisis that occurs or suddenly it becomes necessary and we go, oh dear, what do we do? So with every caregiver that I speak to I always recommend that they begin planning early and to at least speak with an elder law attorney, if only for a consultation about the what ifs or what should I do if. And so tonight, on behalf of Onondaga County Office for Aging and Caregiver Services, I'm really pleased to be able to welcome you all to our Institute for Caregivers 2-part series on the key financial and legal issues in caregiving. And this class tonight is going to focus on enabling you all to identify key issues associated with planning, maintaining control over healthcare, and final decision-making, and even probate, which is a really interesting topic. Tonight, this class is going to be presented by elder law attorney Tim Crisafulli. And Tim, may I say thank you so much to you. We are thrilled to have you with us. And I want to tell everybody a little bit about you. Tim practices in the areas of elder law, trusts and estates, and tax law. His elder law practice is dedicated to assisting clients with long-term care planning. And he also represents clients in Medicaid fair hearings and in guardianships proceedings. Through his trusts and estates practice, Tim helps families protect, preserve, and effectively transfer wealth. He utilizes his extensive knowledge of tax law to minimize capital gains, income, gift, and estate taxes. Tim has an impressive in taxation from New York University School of Law, a JD, magna cum laude from Syracuse University College of Law, a master's degree from Maxwell School of Citizenship and Public Affairs at Syracuse University, and a BA in summa cum laude from Lemoyne College. So you're right, a local boy. So I think we're in really good hands tonight. And thank you again, Tim. I'm going to spotlight you for everyone. And you can share your screen and take it away.
Okay, sharing my screen. Got it. You hearing me okay?
Yeah.
All right, wonderful. Well, thanks so much for having me. It's fun to be here back at the Eye Care series. Proud of everybody for adapting as we all have here. I know we're all old hats at this post-COVID and hopefully post, but where we are with things, everybody's gotten pretty good at remote. Everybody's gotten pretty good at Zoom. So a few things about protocol here. As Kimberly mentioned, this is the first of a 2-part series. Next one is next week, same channel, same time slot, starting at 5:30. Feel free to come back. Feel free to invite your friends. Feel free to invite your enemies. What I would like to do is to just point out a few things to keep this as lively and engaging as possible, though we are in this format of Zoom. First thing I want to be sure of is that you're able to use features. So if you move your mouse around, you should see a comment box. See if you can say something in there. I'm not yet sure how it's going to come up on my display, but even the word hi would be most welcome in the comment box, or a chat. I'm sorry, it says chat. I see one. Somebody figured it out so far. I got a hi from Lisa. Hello to Kelly. Looks good. Again, if there's another one. Thank you, Chris. Looks good. Again, you just sort of hover the mouse around, and then when you see chat emerge, you click in there and anything you type. So anyway, that'll be one way for us to engage. Another thing that you can always do is you can always, again, hover. And then if you click on participants, you might see that opportunity within participants to raise your hand. And if all else fails Maybe I'm missing something in the chat room because my eyes are going all over to different screens. Maybe you can't get your hand up in the participant box. Unmute yourself. Start talking. It'll be just fine. My goal in any presentation is to make sure that I'm being responsive to your questions in real time. Don't wait till the end. The moment something comes up, please be sure to ask either in the chat or by raising your hand, getting called on, or just by unmuting and shouting it out. All right. Next, in the way of overview, I want to thank the Onondaga County Department of Adult Long-Term Care Services for sponsoring the Institute for Caregivers. And as the introduction indicated, I'm Tim Crisafulli from Crisafulli Gorman. My office is in Manlius, New York. Next up, I'm going to see if I'm able to switch slides, and I am. Always nice when the technology works.
Oh, sorry.
So here's how I was thinking of organizing this today. But again, I want this to be your presentation, and I want to make sure that I am doing what it is that you are hopeful of in the time that we have here. It's my understanding this goes until 7, but no later than 7. So we may finish early, but I promise that I will not go long. One thing I want to do is figure out exactly what you came to learn. You're taking moments out of your busy lives. You're joining us. So I want to just take time and jot down the things that you want to make sure that we cover. I may have to punt and push a few things off into next week, but I certainly want to know how many of these things I can respond to today. I want to talk about what is estate planning. There are a lot of, I think, preconceived notions as to what it does not entail. I want to address that head on in our conversation tonight. I'd like to talk a little bit about who needs it. I want to talk about a few of the key documents and explore those with you, some of the ones that most folks have heard of and associate with various levels of estate planning. And I really want to talk a lot about how assets are transferred, what happens in the event somebody passes away, what things move with ease, what things tend to move with a little bit more difficulty, other considerations as they come up. And then all important to me is making sure that we close out well by answering any questions that come up along the way, or to make sure that they have been answered as they come up. So that said, a few things about me. This is where we're going to try to test out the chat box, the raising hands, or the unmuting. This is my background in pictures. Anybody give a guess as to what the first thing here, this pirate looking image, what do you think that's saying about me? I'm looking in the chat box.
Boy, I don't know. Let me see.
Anybody want to unmute and give it a shot? This is more a function of seeing how interactive we can be than actually getting it right.
Come on. Don't be shy. I don't have a clue myself.
Like
My
a
favorite-
Pirates team?
What's that?
Like some type of Pirates team?
Some type of Pirates team. A wonderful guess. Pittsburgh Pirates. Am I into football? I was once asked if I played football for the team. None of the above. It's Oswego. My hometown, the Oswego Buccaneers, is the mascot. So that's where I grew up. As Kimberly mentioned in the intro, I went to Lemoyne College, studied history, got myself a teaching degree because my dad sat me down as I was nearing the end of college, and he said, "So wonderful that you studied history. How might you make a living with it?" So studied education as well, got certified. Then I picked up my first job at Fayetteville Manlius. I taught middle school social studies for 5 years, 7th graders altogether. And then for another 5 years, I went and taught at Fayetteville Manlius High School, also social studies, 9th graders through 12th graders. After that, while married and mortgaged and baby on the way, I thought it might be fun to drive myself and my family into staggering debt. Off to SU Law School I went. Took a job with Hancock Esterbrook in Syracuse. While I was doing that, I got the advanced law degree at NYU School of Law. And I'm currently a member of a national organization called Lawyers with Purpose, which trains other elder law attorneys around the country in how to do many of the things that I'm going to be sharing with you as we go through this. and they're kind enough to fly me around the country from time to time and help me to train other folks in all these great topics that we're going to touch upon tonight. So as I mentioned before, I want to make sure that this presentation is all about you. So what do you want to learn? What's something that you want to make sure gets covered one way or another as we go through our time together today? All right, I'm looking at the chat box. What is estate planning exactly? Protecting assets. Got it. So what is estate planning? How to protect assets. They're coming fast. Kimberly, can you chime in and read a few of these out to me? We'll learn a little bit about Medicaid trusts. Special needs trusts. Trusts. Oh, Rama. A lot of questions centering around trust. EISEP. Not following what that is, Amy. If you can clarify a little bit of that for me, that'd be helpful. Even by unmuting yourself.
Oh, sorry, I'm muted. I'm talking away, Tim, and I'm unmuted. I'm sorry.
okay.
I was reading these off to you and I'm going, why is Tim reading them?
Nah.
Okay, I'm sorry. I muted
That's okay.
myself as well. So yeah, the ISEP program is a program at the county that I think Amy, is that what you were talking about? The expanded in-home services for the elderly program?
Gotcha. Okay.
Okay, so Tim won't be talking about that, but we could certainly do a class on that.
Well, yeah, it's a good healthy list. So even if there's anything on here that we can't get into tonight, and I think we'll be able to touch upon most of them, we could also maybe integrate a little bit into part 2, which will come up next week. So that's good.
So and Kathy says, what do I need to know? I hope you can tell me. That was one. Okay.
Okay, looks good. And again, in general, Kimberly, I won't always be able to see that chat box consistently. So if anything comes up in there as I'm chatting, just let me know and I'll make sure that we get at those things and others.
Okay.
What do I do? What and when? That's a good one. That's a
good
softball, big, broad question. I appreciate it.
What?
All right. So a little bit on what the heck this is exactly when we talk about estate planning. I have found over the course of practice that it really comes down to 4 things overall for people. I think it comes down to control, and I think it comes down to access, I think it comes down to timing, I think it comes down to ability to make changes. I want to explore each one of those things a little bit. A lot of people who initially come and meet with me are wondering if they even need to be there. That term estate, it sounds big. It sounds mansion-esque. It sounds like a lot of wealth. It's not. I like stuff instead of the word estate. It's stuff planning, but it's not just stuff planning. It's people planning, and it's planning for family as well. So let me explore a little bit when I talk about control. I think estate planning is about who's going to be in control. Who's going to be in control while you're alive in the event you lose the capacity to speak for yourself, to sign for yourself, if you develop any sort of cognitive issue. Who do you want to be in control of that? Who do you want to be in control of healthcare decision making? And I think a lot of control goes to who's in control upon someone's eventual passing. Is it entirely in the realm of the court system and a judge to decide? Will the state legislature of New York decide where your assets go, or do you want to chime in and have control over that sort of thing? So I think a huge part of estate planning is control during life and also upon someone's passing. I think another big component of it is access. Who's got access to your stuff? Is your stuff always available to you? Or can situations happen due to health or cognitive impairment where you lose your own access to your own assets? If it's not you, is it someone you chose? Or is it someone else who gets appointed who's able to access your assets? Is it the government? Is it creditors? If you're leaving anything behind to your kids, is it those kids' creditors? Those kids' student loan debts? Who is it that's got access to your assets? I think that's a second critical part of estate planning. And it's who's got access while you're alive and upon your eventual passing. Next is timing. Even if you know you want to get assets to people, well, what if they're too young? Or what if they're not yet mature enough, regardless of age? Maybe there's a timing component to when someone might inherit. And then finally, ability to amend. Once in a while in estate planning, an elder law attorney will throw out the term irrevocable as an irrevocable trust. Does it really mean that? Can it ever be changed? The answer is almost always it can be changed. There's plenty of flexibility. So in sum, when I think about what's estate planning, I view it as taking control during your life, your health, your decision-making, and then taking control upon your eventual passing of where assets go. Then who needs it? Well, for as long as every single human is upright, meaning healthy, has full cognitive ability, then that person does not need estate planning, admittedly. But if ever somebody loses the ability to sign documents for himself or herself, whether temporarily or for good, whatever somebody might lose the ability to tell doctors what they want for their own health care, then they need some estate planning to stay in control of those things, have the world know what they want, and appoint whomever should be in control of making those decisions. And then finally, who needs that part of estate planning that determines where assets go upon passing? Well, I like to think of it as anyone who has died or might one day do so. Obviously, this covers a whole heck of a lot of people. So the level of estate planning that somebody might need can be widely varied, of course, but who needs it? Well, I think that's just about everybody. So what I want to do next is I want to start to explore that there is always some default in place. Most people don't have a will. Most people don't have healthcare proxy, and most people don't have power of attorney. It's actually only about 20% of the population has a will. And I know this with great certainty because I found it on Google. It's got to be true. In all seriousness, though, statistically, most don't. When someone doesn't have a will, the state of New York wrote it for you. When someone doesn't have a healthcare proxy, the state of New York says who's in charge. There's always a default for any planning document that's not in place or that's not effective. So I want to make sure that we explore those two, just so that everybody on the call participating is aware of what these defaults are in the event other plans are not proactively put in place. So I want to start out by talking about a few of the key documents, the ones that most people have heard of. And the first one I want to explore a little bit is the healthcare proxy. Most folks have heard of these. If you've ever been hospitalized or gone into a hospital with someone, you know that during intake, one of the very early questions is, do you have one? And if you don't, then somebody's going to throw a clipboard under your nose and say, sign here. That is a really rough situation, I think, for anybody to be in, because you can't give it the thoughtful due diligence that I think this particular document deserves. But nevertheless, this is one that a lot of people have some degree of familiarity with. This is the one that explains who can tell doctors what to do if ever you can't. Who gets to tell doctors what to do if ever you can't? Now, a huge point that I want to make in the course of this presentation is that not all documents are created the same. I can't tell you the number of times somebody calls my office or is in front of me and says, don't worry, I got healthcare proxy. And I get nervous because I've seen healthcare proxy documents that are excellent. They are exquisite. They are comprehensive. They are thorough. And those folks are in great shape. But then I've also seen some that are like on little cards tucked in a wallet. I've seen some that are not properly executed so that they are without legal effect. I see some that are vague. I see some that are problematic. So on this slide, you got some of the characteristics of those that are either wonderful or not so wonderful, but one way or another, these are things to look for. One of them I nickname the healthcare proxy God proxy version. This is the one where you say something like, I, Tim, nominate my friend Kimberly as my healthcare proxy. Thank you. And that's all it says. Think for a moment about the position that puts poor Kimberly in, right?
Yeah.
Because if I'm unconscious and hospitalized, she gets contacted.
Yeah.
And assuming it's properly executed, she's really in charge. And doctors are really looking at her saying, what do we do, Kimberly? And Kimberly looks at the document and says, uh-oh, I guess I've been asked to just kind of play God here. No description in it as to what my desires are. No explanation as to what interventions I do want, or what events might trigger a desire in me to just turn to palliative care instead of life-saving interventions. So I call that the God proxy, where it's just empty and blank, and it leaves the person to just play God without information. Another provision I like to look for in these is what I call the second bite at the apple. Now, here's what I mean by this. My mom, she had one of these in her healthcare proxy. Now, my mom passed away when I was 25 years old. One of the most delightful things she did for us as a family, is a really big gift, is she had an outstanding healthcare proxy document. She was ill. She'd been ill for a long time. She knew she'd need one day. And what her document included was a provision that said, I don't want you to, now her words would be, plug me in. It was articulated with better legalese than that. It talked about no artificial respiration, no hydration, no nutrition, no dialysis. It said none of that. But then she had this other provision. But if you kids, I'm one of 5, if you kids want to get to the hospital to say your goodbyes, if you want to come in and review the medical charts or pepper the doctors with questions one more time, go ahead. But you only got 3 days. After 3 days, if there's no hope, you must let me go. And I appreciate to this day that she did that for us, because those of us who wanted to and were able to be there, we could be, and we were. For anyone who couldn't be there, it was okay, because she was clear that it was very much optional. And a moment like that at grieving is an individual thing. But there was never a question of, should we keep trying? Should we do another surgery? Should we intervene more? She gave us great clarity, and through that, she gave us great peace. Another thing I look for in healthcare proxy documents is HIPAA, that federal law of who has access to healthcare information. It blows my mind that there are a lot of healthcare proxy documents out there in circulation that lack HIPAA language. Because think of what that does to somebody. It means, hey, Kimberly, I have appointed you as my healthcare proxy, but I failed to give you the authority to look at my medical records? What on earth are you going to base your decision on? HIPAA language is really important to have in these. And then, fortunately, out there in circulation are plenty of healthcare proxy documents that I describe as just right. They explain who's going to be in charge, maybe with a backup or 2 or 3 in case they can't be reached. A really good healthcare proxy has instructions as to what the person does and doesn't want. And a really good healthcare proxy document also has that HIPAA language. Now, I mentioned that we're always going to explore the default here. What if you don't have a healthcare proxy and you can no longer speak for yourself? There's a default. Step one, New York State has created a list of who's in charge. It begins with spouse or domestic partner. Next up is children. On and on it goes. There's already a conflict built in there.
One quick question,
Yeah.
by the way. So, if a person is, whatever the word is, designated a healthcare proxy, they can't talk with the doctors and have ability to see the records?
All right, so here comes the legal answer and the practical answer. The legal answer is, technically speaking, HIPAA language is necessary in order to see someone else's documents, or I'm sorry, someone else's medical records. So if the healthcare proxy document includes HIPAA, absolutely, positively, no question, you got the ability to talk to doctors and get medical records.
So
but if it's not there, now we move to practical. Generally speaking, a doctor, a medical provider is probably going to share information with you. But the thing I always worry about is the disaster that strikes up, because that's when my phone rings, is when something goes wrong. Hey, we've got a brand new intern here who just started a residency, just took the class on what to do and not to do, and is scared. There's no HIPAA. What do? And time ticks by, and time ticks by. So what I like to make sure of is that why not use a belt and suspenders? Why not be sure that that HIPAA language is right there front and center? Why not be safe?
Yeah, okay.
Yeah. All right, so next, there is the default of the state will, and the built-in conflict. You know, if it's spouse, but there's no spouse, or domestic partner, next up is adult children. Well, if someone goes in and claims to be the domestic partner, well, dear old dad is unconscious and somebody's trying to decide, do we intervene or not? Domestic partner says, let him go. Adult child shows up and says, what do you mean let him go? You've been dating for 3 weeks. You're not a domestic partner. I'm in charge here. Confusing. And whenever it's not for sure, the place you go is to court. And court is a hard place to be. It's a guardianship proceeding where the family and everybody who's an interested person gets drug into the courtroom, and the judge ultimately decides who's going to be in charge of medical decision making. Perhaps to make the decisions that dear old dad would have wanted, perhaps not, but absent a validly executed healthcare proxy document, that ambiguity gives rise to litigation, and it's a guardianship proceeding, and it's a rough place to be. So not merely having a healthcare proxy, but having a really high quality healthcare proxy really does matter. Next key document, unless anybody else has anything for chat box or wants to unmute or ask questions about healthcare proxy.
Well, I have one quick question, Tim. It's Kimberly. Does that HIPAA form need to be attached to the healthcare proxy? How does that?
Yeah, so HIPAA forms, people have seen these in different ways. Very often, each doctor someone goes to will have that doctor's own form. What I like to do in a healthcare proxy document that I draft is I embed it right there in the very first paragraph, all caps. I want it to really hit people right between the eyes right away so that they know that it's universal and blanket, whether you're being treated by your longtime physician or whether you're in a hospital, even a hospital in another state who's never treated you or seen you before. So I like to see them embedded directly in the document.
Okay.
All right. Seeing nothing else in the chat room and not hearing anybody else talking through unmuting themselves, I just want to talk briefly about the MOLST. That's the pink form known as Medical Orders for Life-Sustaining Treatment. This is not a lawyer form. This is a doctor form. Medical orders. That's the first 2 letters here, is medical orders. And so what happens with the MOLST is if someone is under the care of a physician and probably in a long-term way, then the doctor can enter medical orders, which might include a do not resuscitate, but it's specific instructions. People are instructed if they're at home to keep these on the fridge or on the nightstand. And if someone's hospitalized, these go at the foot of the bed so that anybody who's in an EMT situation, an emergency, they know right where to look to see if there are any of those. But again, the most is a medical order issued by medical professionals, and they do expire. They don't last very long. It's not a forever document the way a healthcare proxy is intended to be long-term. All right, next key document I wanted to look at a little bit tonight is the durable power of attorney. Healthcare proxy was for all things medical. Durable power of attorney is for all things financial. And when I'm explaining these to clients, I encourage them to think about every place they signed their name in the last year. You signed a tax return, you signed checks, you paid bills, you endorsed checks. You might have applied for some benefits. Heaven only knows what you did all the times you signed your signature. Durable power of attorney document appoints someone else who can sign on your behalf if you can't. Now, just as there are different levels of quality of a healthcare proxy document, there's very different levels of quality of a power of attorney document. One version that I see out there in circulation is what I call the blank check. All right, so, picture writing a blank check to somebody. Take out your checkbook, you sign your name, and you say, here you go. And what they can clear out is immense, right? It's everything in your checking account. You give somebody a blank check on a power of attorney, you can clear out your checking account, sell your house. They have access to absolutely, positively everything. So I call that kind of the blank check version of power of attorney. I hereby appoint my friend Kimberly. Here you go. No specifications, no limits, no modifications. Most people I speak with get a little scared when they hear of such a thing.
Mm-hmm.
Now, I don't want to overstate the risk because there are repercussions. I mean, if somebody fraudulently uses a power of attorney, it's not licensed to steal. They agree by signing it themselves, if they're going to act as agent, that they must act as you instruct. Or if you can't give instructions anymore, they must act in your best interest. They may not commingle property. They have to be ready to give an accounting, all these things. But that's to be sorted out after the damage occurs. They can be held accountable, but somebody's got to hold them accountable. By contrast, if the document itself specifies what can and cannot be done, if the document itself has appropriate limits in there, then the bank presented with it at the outset isn't going to let the problem occur to be sorted out later. So that's the blank check version. The other version I see that are really problematic in my field are the ones that are too weak. So sometimes what happens with a power of attorney document is, I hereby give power of attorney to my wife. Great. But if I then go incapacitated, dementia or anything like that, and I fail to also allow her to make gifts of my assets to herself, or if I fail to allow her to apply for Medicaid for me, or if I fail to allow her to form trusts for me, or to do Medicaid planning, worst case scenario is she's only allowed to pay my bills till I'm broke, till the money's gone. And she didn't along the way have the opportunity to use legal tools, most of which we'll talk about next week at next week's session, to guard my assets against the costs of long-term care. It happens all the time. I'm working several cases right now where married couple, one spouse is in a nursing home. A healthy spouse comes to me and says, can you save anything? I say, I don't know. Can the spouse in the nursing home still sign papers? How's the cognition? Can't do anything else. Oh, do you have power of attorney? Yeah, I got power of attorney. And I really cross my fingers because when they slide a document across the desk, I hope to my lucky stars that it's going to be expansive enough and not too weak. Sometimes they're too weak. And when that happens, our options are sadly very limited. The ones that are just right, they are expanded, meaning they allow the agent to do all the things necessary to honor the person's wishes. But they also have instructions to rein it in a little bit to reduce the risk of having to fix a problem after the fact. Just as with the healthcare proxy, there's always a default. If I've got a family that comes in and says, look, we got to get long-term care in place. We got to structure assets to reduce taxes. We got to take some measure to protect our loved one who can't sign documents anymore. Well, if that loved one didn't do a power of attorney, we're back to court. And it's a guardianship proceeding. And guardianship proceedings, again, are hard, because what you're doing is you're hauling the person into court. You're saying that that person no longer has the ability to exercise the rights of a U.S. citizen. And you're convincing all the family and all the interested people who should be in charge. These proceedings are hard emotionally, they're expensive, they take time. It's a rough place to be that could have been fixed with a good durable power of attorney. They're there, it's the default, you can use them and they work, but they're just hard. Before I move past the durable power of attorney, any questions on that?
Nope. Doesn't look like it.
Okay. All right, next thing I want to do is I really want to spend some time looking at how assets move in the event someone passes away. So this is an overview slide that I'm going to develop just a little bit at a time and talk about different words within here a little bit at a time. I tried to make this slide really, really simplified so that you could get the image in your head, and everything falls under here some way or another. But there's a lot of complexities that swirl around each of these terms. So if you follow along, what you'll see is that when somebody passes away, there are only two paths down which every asset must go. Either the asset is going to go down the side that says estate, or the asset is going to go down the side that says operation of law. There are no other paths. There are no other choices, whether it's $1 million IRA or whether it is the salt shaker on the table. These are the only two paths available for every asset that a person who passed away owned. Now what I want to do is get into these a little bit at a time. So you'll notice under estate, we got two different possibilities. There's intestacy and there's a will. Intestacy means if somebody passed away without a will, no worries, there's a default. The great state of New York wrote one for you. That's what intestacy is. If somebody did write a will, then your assets that move down that left side, estate side, those are going to go wherever the will said. But if it's going down that side that says estate, it's moving by intestacy if you didn't have a will, or it's moving according to your will. So let's explore that side a little bit, and then we'll come back later in the presentation and talk a little bit about operation of law. So first up, intestacy, where there is no will. The rule is, here's who's getting your stuff. This is your next of kin as defined under New York law. If someone passes away with a spouse, but no children, then everything goes to the spouse only. Period. End of story. Next, if someone passes away with children only, so no spouse, just kids, then everything gets equally divided among the kids. That's it. I've got language there that says per stirpes. So what that means is, if a child of yours passed away before you, leaving children of his or her own, that's your grandkids, then what would have gone to your predeceased child will instead get equally divided among those grandkids. That's what per stirpes means. Next, if someone passes away with both a spouse and children, then what the state of New York says is if you don't have a will, the surviving spouse must get the first $50,000, and the surviving spouse must get 1/2 of what's left. The other half must go equally among the children, regardless of their age, regardless of what's going on in their lives, half of it equally among the children. Got a question in the chat box.
Oh.
So are we talk? Oh, is that what you were doing, Kimberly?
Yeah, I was just going to let you know. Go ahead. Can you
Yeah,
read
so
it?
the question in the chat box, are we talking biological children or stepchildren as well? I'm going to expand that a little because we got 3 possibilities. We got biological, we got legally adopted, and then we've got step. Different states answered this question differently. In New York, for the intestacy purposes that I'm talking about on the screen right now, whenever I say kids, that does include biological children. That does include legally adopted children. That does not include stepchildren. I get cases all the time where it's a really, really sad result. I'll get the biological child and the stepchild in my office, and the stepchild saying, this person was a mom to me. She came into my life when I was 6 months old. I've always called her mom. She always told me that I was going to be in on things. Well, I'm sorry, you weren't legally adopted. You have no right to inherit. It's tough. People rely on these defaults or don't know about them. So anyway, that's the answer. Does not include stepchildren. If someone passes away, no spouse, no kids, no grandkids, no descendants at all, then the next of kin is parents. Now think about how that might be problematic. You know, a lot of people say to me, well, yeah, I don't have a spouse, I don't have any kids. Yeah, I can go up to my parents. That can be the biggest financial disaster, because what if the parents are in a nursing home themselves? All of a sudden they inherit all this money and then it just has to go away to the tune of $16,000 a month. Whereas with a will, it could have still gone to the parents, but in a protected way that we'll talk about later. Or it could have gone to someone else who was not the default, who, is in a position where they may not be able to hold it. Next up, if no spouse, no kids, no descendants, no parents living, then to siblings. If there are no siblings, or if a sibling predeceased, then down to nieces and nephews. If no nieces and nephews, now we're making the genealogists excited because we go out to cousins. And then that's it. The very last inheritor is called Ishiat. It means the state of New York. It's really easy to remember. It's oh, Ishiat, I forgot to make a will, and therefore the state of New York is going to get all the stuff I earned. So anyway, that's intestacy. That's the lineup in the event somebody passes away with no will. And I should add here, without a valid will. I had this case one time. Oh man, this was a cool one. So what happened was this gentleman had taken great care of his elderly second cousin once removed. Okay, so you see we're already off this list. He took care of her. She lived in a house that was falling apart. There were a lot of cats. There was a hoarder issue. He was mowing the lawn. He was bringing her food. He thought she was just broke. Not good. When she died, he started looking through her paperwork to clean up a little bit. She had $1.2 million just sitting in the bank. She just didn't spend it. And in those papers, he found a note, said, I leave everything to my sweet second cousin once removed, named his name. He took good care of me and he deserves everything I have. He brought it into me, shaking a little, and I picked it up. I was shaking. I was excited. I was a brand new lawyer at the time. He said, is this really, is this going to work? Is this good? She signed it. She had it notarized. But that's not the rule in New York. The rule in New York is for a will to be valid, it has to be signed by the person who died and 2 witnesses. Doesn't have to be notarized. So because it was not validly executed will, she didn't have a will. And instead her assets moved by intestacy, and it all went to the 2 cousins she had, neither of whom she met and who lived far away in the country. So it's not just having a will, that the absent a valid will, intestacy prevails.
Hmm.
So that's intestacy. Before I move over and start talking about a will, any questions on this, whether in the chat room or because you want to unmute? Okay.
Nope. Okay.
All right, then still on the left side, if things go down that left side, they must either pass through intestacy or with a will. Here's what's nice about having a will. If you got a will, valid will, you got choices. You can decide who the beneficiaries are. You know, it could have gone to that second cousin once removed. You pick who they are, the state doesn't under default rules. You can determine what specific items specific beneficiaries receive. If you don't specify in a will, then it's just percentages, and it's up to the executor or the administrator how to divide everything up. But if there's a sentimental item or a particular asset that you want to leave behind to a specific person, a will enables you to do that. Next up, we got how beneficiaries inherit, and I write outright or in trust. Now, in this example, I pick on my wife. My wife, whom I love, who is perfect, who walks on water. She is delightful in every which way. And I'm scared to death when she drives the car. I just am. Maybe it's in my head. She knows I feel this way. We talk about it. Among my great fears in life is that she's going to be driving. I'll be in the passenger seat, and she's going to cause the mother of all accidents. And I'm going to die in that accident. If I leave everything to my wife and just say, here you go, dear, and I just put it all in her hand, because that's what my estate plan does, got no will maybe, or my will just leaves everything to her. Well, where's it going now? Can she keep it and use it for our kids? Well, if she caused that accident and she hurt somebody, well, maybe it's going to go to the person who got hurt in the lawsuit, and there won't be anything to support our children. Or maybe if I left everything to her in her hand and she has medical expenses not covered by insurance, maybe that's where it's going instead of to support our kids. Or if I leave everything directly to her, you know, in advanced years, and then she needs a nursing home, it's all just going away and not to other beneficiaries. So with a will, you're not forced to just leave things to people directly. You have the opportunity to leave things to people in a protected way, in a trust, which I'll elaborate more on today and especially next week. Point is, you got a choice as to how somebody might inherit. You're not limited to just, here you go, in hand. A will can give you an opportunity to say when beneficiaries inherit. I am blessed with a 17-year-old and a 15-year-old and a 7-year-old. It happens sometimes. My 7-year-old is not up for inheriting wealth. When he turns 18, he is not going to be up for inheriting money. Somebody's got to watch that money until he reaches an older age. Some days I think it's 25. Some days I think it's 35. We'll see. But the point is, you get a choice as to when beneficiaries inherit. And lastly, you get a choice as to who's in control. If I've got a will, I can decide who's in charge of my kids' money until they're old enough. But if I don't have a will, that decision rests with whomever got elected as surrogate court judge in our county. So that's advantages of a will as opposed to intestacy. Basically, it's a lot more choice and a lot more flexibility. Before I move on, are there any questions about a will?
I have a quick question, Tim.
Sure.
Is it, and I ask you this because I see a lot of this on commercials and so forth. Can a person create their own will and have it witnessed by two people, and that's legal?
All right, so direct answer, yes.
Hmm.
Story time. I can fix my own plumbing in my own basement when it's flooded. There's nothing preventing me from doing that. But there's a great risk that it's just not going to work out properly because I don't know what I'm doing. I can even look at some YouTube videos. I can even download how to do it. It's going to be a problem. Is it legal for people to do their own wills? Absolutely, positively. Is LegalZoom out there? It sure is. And I love LegalZoom. I can't say enough good things about it, because the amount of money I charge as an attorney to draft a will, that much. The amount of money I charge as an attorney to sort out something that went wrong with a LegalZoom will, that much. So I really love LegalZoom. I'm being a little flippant there, and you know you're going to get a biased answer from this from a guy who is an attorney. Is it possible to do your own documents? Yes. But be careful out there, because you don't know what you don't know, and people often get hurt doing it. But as long as it is properly drafted, properly witnessed, and you fulfill all 7 of the legal requirements under the pertinent statute for how to properly execute a will, it works.
Okay. Thanks.
Hope my answer wasn't too cutesy, but I've seen it go wrong a lot. I'm sure it goes right a lot too. Okay, so that's a will. So that's the estate side. The last thing I want to talk about the estate side, because you remember the whole broad picture here is when somebody dies, every asset must either go through the estate, whether by intestacy or will, or there's going to be an alternative we look at in just a moment. To finish up with the estate side, I want to talk about the process. And the process is about identical regardless of whether intestacy controls or whether the person had a valid will. The process looks like this. This is the estate administration process. Step 1, find the original will. Photocopies don't cut it. A lot of cases break down right there. People show up with a photocopy and they can't find the original. That's a mess. Every time I say mess, that's a lot of money. It's a lot of sorting out to do. It's a big problem. Anyway, find the original will, or if you can't, or if there isn't one, you will let the court know that you're proceeding under the rules of intestacy. Step 2, hire an attorney. Step 3, the attorney puts together papers to petition the court or to ask it to appoint someone as executor or administrator, and then if there's a will, to find it to be valid. At that point, the invitations go out. I call them invitations flippantly. It's the invitation to object. Everybody with a legal interest in the estate either signs a waiver saying I'm good with this, or if they won't, a process server is hired who goes and finds them and gives them a court date. At that court date, if they want to fight and file objections, they may. And then you can start trial number 1, which is a will contest and litigation to decide whether the will's valid and who gets appointed to be in charge of the estate. Ultimately, someone is appointed, and then we all sit and wait for 7 months, just in case the person who passed away owed money to anyone. Any potential creditors have up to 7 months to come forward and make a claim against the estate before it can be fully distributed. After the 7 months ends, you can begin the process of closing the estate informally. If everybody signs off on it and says, good job, executor. If anybody wants to complain about the executor, they can demand a formal proceeding. And again, we're back for more litigation. This time it's called an accounting litigation. Once it's sorted out, either by consent or because the judge said so, the estate can be closed. Usually takes about 9 to 15 months to probate an estate if there are no surprises and everything's smooth. Otherwise, they can go for years. And then there are costs, commissions, and fees that go along with this. And probate can become expensive quickly. The executor is entitled to 5% of the first 100,000 that moves through probate, 4% of the next 200,000, and on it goes. And then there are also legal fees, and those costs are court costs. So that's what it looks like. If something's going down that estate side, either by intestacy or through a will, that's the process it's got to go through.
Okay, I have another question. It's
Sure.
just me again, Kimberly. Someone asked me this, and I don't know the answer to it. when an individual passes away, when the estate is in probate, is it necessary to put a notice in a paper or some publication to alert possible debtor, folks that they owe money to, that
Okay.
they've passed away? Or is
Yeah.
that just a courtesy?
Yeah, so I got to give you the lawyer answer. It depends.
Oh,
So first thing it depends on is what state are you in? There are some states that require publication just as you described it. New York is not one of them. In New York State, it is not necessary to publish to make creditors aware. The assumption is that creditors can scan the court records all on their own, find their decedents that way.
okay.
That said, though, sometimes if you're looking at the legal notices in the Syracuse newspaper or any newspaper, first of all, you must be bored out of your mind. But second of all, if you happen to open it up and look at those legal notices, sometimes you'll find a description of an estate. The time when publication happens is if you can't find all the people. Like there's a long lost son, or we think there was a long lost son. If you can't find every single person, then what a judge might do is say, well, you're going to have to publish in 2 newspapers in the cities where the missing person is most likely to have last been. Then the judge will allow you to proceed. So an estate can really get held up for a long, long time at this point of waiver and service, because if you don't know where all the people are, you got to either find them or convince a judge that you tried hard enough to find them and then resort to a publication.
So when you do resort to a publication, is there a waiting period for that response? I mean, do you have to wait another 2 months, or can you
Yes.
say you do? Okay.
Yep. Generally speaking, a court will require it to run 4 times over the course of 6 weeks.
Okay. And that is also in New York State?
Yes.
Okay, got it. Thank you.
Yeah, you bet. Thanks for the question. All right, so that's a look at for those assets that move through the estate, whether by intestacy or through a valid will. There's a whole other possibility here, right? We talked about how when somebody dies, every asset must go through the estate, or it may move by operation of law instead. Operation of law describes how assets move if they don't have to go through the estate. And if something is moving by operation of law, that thing doesn't care about the rules of intestacy. That thing doesn't care what the will says, doesn't even care if there is a will. And anything passing by operation of law does not have to go through that whole process that we just looked at. There are no courts involved if something's moving by operation of law. And instead of it taking a court process and a year or more to move, an asset passing by operation of law can either move instantly or really darn quickly. So that said, there are only 3 different ways to move an asset by operation of law instead of through an estate. I want to just take a moment and explore them one at a time. First way to move assets by operation of law instead of through the estate is with joint titling. So for example, a really common example is if you've got a married couple, they were married when they bought their house together, their names are on the deed in the right way. Then when one of them passes away, the surviving spouse just instantly owns the house. Probate doesn't matter. Existence of a will doesn't matter. It's done. Same thing is true of other kinds of assets. For example, a bank account. Sometimes if a checking account is jointly titled, when one owner dies, then the surviving owner instantly owns the whole asset. A will doesn't matter. An estate proceeding is not necessary. It just belongs to the survivor. And that's how joint titling works. Next up, we have beneficiary designations. Beneficiary designations come up most often with assets like life insurance policies, IRAs, 401ks, 403bs, the sorts of assets on which you're allowed to designate a beneficiary. And when that happens, the asset goes to those designated beneficiaries quickly. Usually takes about 2 to 3 weeks, because all the beneficiary needs to do is get an original death certificate, fill out the claim form for whatever company is holding the asset, send them on in, and then the asset moves. So beneficiary designations are another way to move things by operation of law really darn quickly without having to go through that whole probate process. Now, at this point, a lot of my talks get fun, particularly if there are any engineers in the audience, because they sit back and they look at me. It's more dynamic in a live presentation. Zoom's a hard thing. But they sit back and they look at me and they say, Crisafulli, you damn fool. You just explained to us why lawyers aren't needed. You just showed us the way to never need a will, to never need a trust, to never need anything. Because if we go out into the world and we make sure that every single thing we own is jointly titled or has a designated beneficiary, then that's it. The asset just moves instantly. It's cheap, it's easy, it's done. Thanks for your time, Tim. We'll never need any lawyering. Fool. Okay, I get it. However, think back to the story I told you of my wife's driving, remembering how much I love her. If I leave everything to her directly in hand, regardless if it's through my will, or if it's by joint titling, or if it's by designating her as beneficiary, if it all goes to her directly in her hand, there's no way to protect it if something goes wrong thereafter, like she needs a nursing home thereafter, or like something goes wrong in her life thereafter. Another problem with joint titling, the slide before, if I jointly title my assets with my son, well, yeah, I'd avoid probate if I died, it'd just go to him. But my gosh, what if my son gets divorced? Well, now that jointly titled asset is kind of his too. Got to sort out who does it really belong to. Or what if he has a creditor or a levy and a judgment? Can they just reach in and take that jointly titled assets? I mean, another way to put it is if I jointly title my stuff with somebody else, well, now it's jointly titled with that other person and subject to that other person's issues in the world. And maybe a way to easily and cheaply avoid probate, which it does, might open up a whole Pandora's box of other issues. Another time when I see something similar to joint titling is when people will put the kid's name on the house, right? So what they mean by that typically is they'll say, well, I'm going to keep life use of my house, but make it be owned by my kid. So that's sort of a mix between joint titling and beneficiary designation. If you've already done it, okay, let it ride. If you haven't done it, I generally don't recommend it, and here's why. First, you destroy all flexibility. You can't sell that house without your kid's permission. Oh, don't worry, Tim, I got a good boy. I got a good daughter here. Yeah? Well, what if your kid passes away before you? Well, now you have life use of a house owned by your kid's estate. And where's that going? Did your kid have a will? Is it intestacy? I don't know where it's going. If you then need a nursing home and the house has to get sold, it's not all going to the kid. When it gets sold and you're still alive, your actuarial interest in your life use of that house, it's a calculatable amount, and that gets lost to a nursing home. So the point about operation of law is it is great for avoiding estate administration. It is great for avoiding intestacy. It's great for avoiding probate. It is great for simplicity and ease. But it's not a one-size-fits-all catch-all for all situations, because it can give rise to other things if done without careful thought.
Okay,
Before-
Tim,
yeah.
it's Kimberly again.
Yeah.
I'm sorry, quick
Yeah, I
question
love
here.
Yeah,
Question
go ahead.
here. So if a parent decides to make that, I don't know what it's called, a designation, title the house in their child's name, but keep use of the home, can they include within the terminology of that document that if their child predeceases them, it would revert back to them? Or is that just a one-way street?
I must give the answer. I don't know for sure if it's theoretically possible. I can definitely say I've never seen it done. I've never looked up if I've never seen it because it's prohibited or because I just happen to have not seen it.
Because
It would be
most
very-
parents wouldn't think about it. I never thought about it till you just said it.
Right, right. I mean, and just understand where I come from. I mean, the times I see a reserved life use deed, that's what it's called, right? I gave it to my kids, but I kept life use. The time I see those are when it didn't work out. And the
Okay.
time when it didn't work out is if the kid died first.
Hmm.
We got a problem. Then what happens is the house, wherever it's going to go, it's still going there subject to the life use. So you're kind of living in a house that's owned by somebody else.
Yeah.
I think, as I think through your original question, it's called a reverter. If it could revert back to the person who originally gave it away, that's kind of an unsettled title until all facts played out, and so it can give rise to complications.
Okay.
Yeah, point is, it's not as clear cut as a lot of people assume. I'll just put my kid's name on the house.
Yeah.
There can be issues that arise. Sometimes it's the right thing to do. I generally steer clear of it. One other thing with beneficiary designations before I move on and then hit my last couple slides is IRAs. I just want to give a quick talk about IRAs because if you get your beneficiary designations correct, then whomever you leave an IRA to, same thing for 401k, 403b, they get years and years and years of continued tax deferred growth. It's tax magic and it's investment magic if you do it right. If you get it wrong, then that tax deferred growth just goes away. And whomever inherits it has to very quickly take it out of that tax deferred realm. And maybe in just 1 year's worth of time, if they really screw it up, they take the whole thing in their income and they pay a great big tax in that first year. It's complex to get IRAs correct and beyond the scope of what we're doing today. But the big assets that most people have in the world, they got a house, they got an IRA. And if you get the house titling right, you can get nice perks. If you get beneficiary designations with IRAs just right, you can get really nice perks. But if you get them wrong, there can be some rough consequences with it. Last tidbit on this particular slide is lifetime trust. And this is something that is really the topic of next week, because next week we're talking about, well, if there are big long-term care costs, how are we going to go about protecting assets? And very often the answer to that question is through some use of a trust. And as I look back on some of the questions that y'all put in the chat box of what you want to learn through this two-part series, I said, please talk about Medicaid trusts. That's a big topic next week. Please talk about special needs trusts. That's a big topic next week. I wrote trusts over Alma. But I do want to touch upon it a little bit here. So every other time I've used the word trust in this conversation today, it was a trust after somebody had died, and I probably did that with my hands. I was talking about inside your will, you could make a trust for your surviving spouse. If your surviving spouse is a really bad driver, you make a trust for your surviving spouse. Surviving spouse can get at it, but it's protected from anything else that might take it away out of an open hand. Or you can make a trust for a minor child after you pass away, instead of just leaving it to the kid directly so they get it all when they're 18. As I talk about lifetime trusts, though, these are not trusts that wait until after you pass away to come into existence. Rather, a lifetime trust is one that you create now during your lifetime that requires some care and feeding now during your lifetime, and which you put some assets into now during your lifetime. Broadly speaking, a lot more details to follow next week, but broadly speaking, there are two overall categories of lifetime trusts. You've got revocable and you've got irrevocable. A revocable trust, I always describe as a big open box, meaning you can reach in there and take things out or put things back in anytime you want. You got total control. It's as if it's your pocket. You do anything you feel like with that revocable trust. And what that does accomplish for you is it moves things over to that operation of law side. So if you've got an asset and you put it into your revocable trust while you are alive, well, now that asset's going to move by operation of law when you pass. No probate, no invitations to come litigate, no courts, no year or more. Something in a revocable trust can move very quickly and efficiently and cheaply. The second major category of trust is an irrevocable trust. And an irrevocable trust sure sounds permanent. There are a lot of different reasons to use these. Over time, they've been used to reduce estate taxes, but barely anybody cares about estate taxes because as New Yorkers, we don't have to think about them unless we're leaving more than $6 million behind. It affects very few people. But one use of irrevocable trusts is to reduce estate taxes. A whole other use of irrevocable trusts, and is what I use mostly in my practice, is to protect assets, mostly from the costs of long-term cares or from creditors, for people who work in fields where they're concerned about being sued. But frankly, most of my use of irrevocable trusts in my practice in the Onondaga County and surrounding county areas, it's all about putting assets in there so they get protected if ever my client needs long-term care or my client's spouse needs long-term care. They're effective if you're able to plan way ahead of time, 5 years, like we'll talk about next week in specifics, or they're of use if somebody's already in a nursing home and you very quickly need to have a place to put an amount that you're able to preserve. There again, the irrevocable trust is useful. For purposes of tonight and for purposes of this slide, the main point is if every asset must move down one of two paths when somebody dies. If it's going to go through the estate, it's going to get where it's going through intestacy or through the will, through that probate process that we talked about, or that administration process. By contrast, if an asset is able to move by operation of law, it's not moving through probate, it's not moving through administration, it's not moving through the courts. It can move either instantly or quickly. And the three ways to move an asset by operation of law are with joint titling, beneficiary designation, or by the use of a lifetime trust, whether that trust be revocable or irrevocable. So with all this, to bring it back to Institute for Caregivers, what do you do with all this? If you're thinking of this for yourself, okay, you got some good background here. If you're thinking of this for someone for whom you are a caregiver, what do you do with this knowledge? What I would suggest for some very tangible takeaways, things you might want to haul off and do with this. First thing to consider, I think, is that not all power of attorney documents are created equally. So if there is someone in your life who needs a caregiver or for whom you are a caregiver, if at all possible, if this person has the ability to sign documents, let's make sure that that person has a really good, solid power of attorney document. Because what you don't want is the position to arise where, okay, we got to do something for this person, whether it's apply for Medicaid, nursing home, whatever it is. And then after it's too late for them to update it, that's the first time it comes out of the drawer. That's the first time it's realized, uh-oh, this one is not sufficient to allow us to do all the things we need to do. So make sure there is a power of attorney and make sure it's a good one. They're not all created the same. Next, same thing with a healthcare proxy. If the person, well, first of all, evaluate what's in existence. Now, if the answer is nothing, get one for yourself too. If there is one in existence, make sure it's a good one. Make sure it has the HIPAA language. Make sure it conveys what the person's interests are and that it's not just that God proxy of, all right, daughter, you're the one in charge. I hope you know what I want, and I hope you don't fight about it with your siblings because I never articulated it or wrote it down on paper. So make sure you got the documents, make sure they're good. A MOLST also, if appropriate, but again, that's not a lawyer document, that's a doctor document. So if you've got someone for whom you are a caregiver who's regularly seeing a physician, ask that physician about the MOLST. Maybe that physician will determine it's appropriate, maybe not, but at least have the conversation. Last thing I want to do is not instill panic. Having any document is better than none. If you got no document at all, hey, there's always a guardianship proceeding. It's not as good as simply having a power of attorney or a healthcare proxy of high quality, because those are just so much easier. But if you can't, you can't, and a guardianship it is. The other thing I want to say is about mental capacity to execute these things. Even if somebody's already been diagnosed with dementia, that does not necessarily preclude that person from signing these documents. The legal test is lucidity. Some days are better than others. But if you get someone who's having a really good day of lucidity and they can identify who the loved ones are, natural objects of their bounty is the legal term, but if they can identify who would likely get their stuff, they might choose to disinherit, but who would likely get it? If they can identify approximately what they own. If I got somebody in front of me saying, I own Windsor Castle, yeah, we're probably not signing a document. But if they've got an approximate, well, I do my banking at KeyBank and I got a house and there's an IRA and they roughly know about what's in it, good enough. And then finally, do they in general terms understand what the document does? I don't need a legal interpretation of it, but if somebody can tell me that a healthcare proxy document lets someone else tell doctors what to do, that's showing enough capacity to do it. You got to convince the two witnesses and notary who are there, or whomever is required to sign the document. Point is, maybe it's not too late. Last will and testament, just smart to have. I guess unless intestacy fits perfect, but intestacy I have seen bring about lots of surprises. And remember that not everything's going through probate. Even if you have a will, a lot of people make this awful error of thinking, all right, I signed my will, it's done. That's where all my stuff goes. Oh, no, it's not. Because if you've got joint titling of assets, there are surprises. If you've got designated beneficiary from years and years ago, a classic one is when I started my job back in 1990, I was dating this nice person. So I figured, what the hell? I'll name her as my 401k beneficiary. Never changed it. Broke up years ago, remarried. We're married. Wow, what a surprise for that other person from 1990. So anyway, getting those things up to date really matters.
Dear.
Next week we're talking about asset protection and we're talking about trusts. Talk about asset protection. How do you afford long-term care? Nursing homes in this part of the state are about $16,000 a month, anywhere from 13 up to 16. That drains money fast. Is there anything you can do? The answer is yes. Is there anything you can do even if it's the last minute or somebody's already in a nursing home? The answer is yes. You might not get as good a result as possible if you did pre-planning years ago, but there's still a lot that can be saved and a lot that you can do. So that's really what we're centering on next week. I want to just go back to the questions that you asked. You asked, what's estate planning? I think we covered it. How do you protect assets? That's much more of next week, but not entirely, because this week we talked about how do you protect assets for your loved ones? Like, how do I protect assets for my wife? Well, maybe it's not leaving her assets directly in hand or relying too much on joint titling or beneficiary designations, but maybe it's by wrapping it in a trust in the way of an example. But we'll talk much more next week of how do I protect my own assets while I am still alive. That's a lot of next week. Medical bills, there again, if I leave assets directly to a spouse, that money might go away, but I leave money to a spouse wrapped in a trust, then whatever I have wrapped in that trust is not forced out to pay for medical bills, provided the trust is worded properly. We'll talk a lot about long-term care next week and Medicaid trust next week. All the trust stuff comes up next week. And in what order to get things done. Say it starts with an inventory. If you're going to really take on this project, learn things. Go out, learn, interview a few different attorneys, decide who you're comfortable working with. Not all documents are created the same. Not all attorneys are created the same, but learn things. Learn things is good. What I want to do for the last slide is to what's next. We've got next week's Paying for Long-Term Care, Understanding Your Options. It's November 9th, 2022, beginning at 5:30. I always end on time. I got 2.5 minutes to go. I'll be done on time tonight, and I'll be done on time next week. If it turns out you do come up with questions after this ends in a couple of minutes, then what I would say is check out my website, www.cg-lawyers.com. It's on the materials. If you want this slideshow presentation and every slide that I showed, reach out to Kimberly. I've already given them to her in PDF. You can get them all that way. My contact information is there. You can also Google me. If you do have a question, what you will see when you get to my website, just to let you know exactly where to find everything. Go over to contact us. And when you get to contact us, if you just scroll on down, write your message in here, I'll get back to you. Okay. And then if you find anything else on the website that is helpful to you, all the better. So with that, thank you. I had a great time. I'm coming in 90 seconds early.
Well, I
Always
have
on
one quick
time.
question though, if
Sure.
you don't mind.
Yeah.
One quick question, because at the county, we have a great document called Peace of Mind that when I send a follow-up email to everybody, which will include the slide sets and how to contact you if they have questions. The power of attorney form that is in there was the most recently one offered through the New York State Bar Associates. It is the New York statutory short form, which seems pretty thorough. Is that an okay form? That's the one that we're offering to people. It has certainly lots of options for modifications and so forth and designations. So are you familiar with that? Is that?
I am. I would say it's good, not great. That's my personal opinion of it, and I'll tell you exactly why. So the power of attorney form, the state legislature wrote it, period. And that's exactly what your form is. The New York Bar Association took exactly what the state legislature signed into law and said, here you go.
Okay.
But what's possible in there, it's in paragraph B, and it says modifications. That's where a lot of attorneys, myself included, will add things like the power to make a trust. That's not in the default one. The expansive power of modified gifting, so that spouses can move a lot as between each other to preserve assets. That's not in the standard one. So it's good, but in my opinion, it could be better. And I have sometimes seen people execute it in a way where they don't check the right boxes or sign the right places. And so it doesn't do all the things that they might need. So not awful, but I think better is possible.
Okay. Okay. So one more follow-up. I know we're right at 7 o'clock, but
But it's your fault that we're late now.
I know. It's my fault. Under the modifications optional section, is it possible for someone, just to draft that and attach that as a modification to the POA, what you were just talking about? Or is that something that would need to be done through an attorney? Because this does need to be, well, no, it doesn't. It's just signed.
Yeah, so I would say it's back to doing your own plumbing. Yes, you can.
Okay.
It is legal, but be careful.
Okay. All right, so you would actually recommend going through an attorney to do a POA? Okay,
Yeah, I understand I'm biased, but you know, I clean up a lot of messes day to day, so. that's-
okay, all right. Okay, well, Tim, I can't thank you enough. It was absolutely wonderful. Tons of information, tons of questions that I have in my head. Does anyone have any further questions for Tim before we say goodnight? I don't think so. I'm the one that always has the questions. Okay, all right. So I'll send out a follow-up email if you haven't registered for the class next week. The registration link will be in that. And so you can register for that. And I hope we see you all and others next week. Thank you so much, Tim. Go home, have a good night. And good night, everyone. Thank you so much.
All right, my pleasure. Thanks.